Yeah, good to meet you. Appreciate you. Yeah, yeah, that's fine. Okay, well, I'm sure I know what this is about.
He'd rather copy first, Mr. Attorney,
Yeah.
so he can go through that while you're, thank you. I just think that'd be a good idea.
Yeah.
What did you finally decide on for finish, Shelley? Pardon? What did you finally decide on? You got any on you?
No, but I saw all of it.
Oh, that's good.
It's funny, you'd think being before Easter, but on Friday, there's something, I didn't sell much on Friday, besides something. That's just good. You know, something I noticed, Alaska halibut's a little fattier on the outside than like other divisions.
Has to do with water
Yeah,
temperature,
it
I'm
sure
sure.
does.
Yeah. You'd want a little pat on your
Yeah, it's
view.
good.
Okay, we're gonna start the study session. Today we're probably going to, it's probably gonna revolve around the solar energy facility ordinance and anything we just absolutely need to talk to. But first, I'd like to see if Samantha would like to, do you need the floor to talk about anything on the ambulance service? Okay, well, I wanna give you an opportunity.
Do you guys have any questions?
Okay, thank you. Do you want to introduce your guest?
Yeah, as you're aware from our previous meetings, I've been communicating with Andrew Best, Andrew Best, that's where my mind is. Andrew Kite,
That's a good
who,
one.
yeah, who is with Kyle Royster. He's the one that I had listened to at the last UCCI meeting that I had attended on independent best requirements and ordinance, and then in the meantime had found out that through conversation that our solar ordinance needed to be updated if a BESS was going to be incorporated into a plan. So we've been communicating, and Andrew came today to present to us what the ordinance draft is and how it has updated what we already had. So I yield the floor.
Yeah, okay. So I'm Andy Kite. I'm, as Lisa mentioned, I'm from Kyle Royster. Just for familiarity with how the process works, typically we are retained through your state's attorney. And so we act at the discretion or direction of your state's attorney on what services we provide then to the county. In this specific instance, we'd be helping you revise your ordinances to help meet whatever challenges you might have in the solar and battery storage world. And so that's our kind of our role, is kind of walk you through that, and then if there's any projects that come up, if you need our assistance with that, we can help you too. But with that, I'm gonna walk through first kind of a 10,000 foot overview on regulating and how we do that within the context of solar projects and battery storage projects. And then I'll walk through sort of the differences. You have a solar ordinance already, and I'm gonna kind of walk through what some of the changes are or suggested changes. It's helpful in that your ordinance kind of already follows very closely a sample that we worked on with the Illinois Association of County Board Members and the Farm Bureau back when the whole statute passed back in 2023. But as we go along, feel free to interrupt me with questions. I'm going to try and be as efficient as I can and try and cover them both here in probably 20 minutes, half hour. So,
Is the company that put in the solar farm, do they put in the BESS also, or is that a separate company that does those?
it's usually, if there's a BESS that's part of a solar project, it's usually the same company.
Same company?
Yeah. So let me start back in 2023. I think you guys are probably aware, since you passed an ordinance that complied with the statute. The statutory scheme changed in Illinois. It essentially requires counties to pass certain requirements essentially guardrails that the state put in place. Those guardrails needed to be passed by then an ordinance, which you guys adopted. Follows pretty closely with that state statute. And then as part and parcel of that, there was both wind and solar ordinances that you could pass. Now, you guys are a little bit unique. There's, in Illinois, there's essentially two types of counties when it comes to zonings. There are those that are formally zoned under the county's code. So you'd go through a whole process of passing a unified development ordinance under the county's code, and then you would have a zoning board of appeals that hears projects that may come before them. But as I understand it, you guys are not zoned. So you don't have zoning, but the state gave you authority to pass ordinances regulating wind and solar projects back in 2023 when they passed their state statute regulating wind and solar projects. So with that kind of backdrop, then the ordinances that the counties all had to pass had to be in conformance with what the state told them they had to do. I don't get into the politics of all that. I was somewhat frustrated by it myself, but that's what they did. And so when you guys passed your ordinance in 2023, it looks like you took that form or sample ordinance that was circulated by the Association of County Board Members and the Farm Bureau, which is one we had worked on, and it follows pretty closely with that. There's a couple things that I would probably recommend some changes on. But before I get to that, when it comes to battery storage, in Illinois, it kind of takes two forms. It either is going to have a standalone project, so it's battery storage that is not connected or part of a wind or solar project. Those are becoming something of in vogue. The technology is essentially advancing to the point where you may see standalone battery storage projects. The other version, which is one that's been around for a little while, is you would see battery storage that is part and parcel of a wind or solar project. And so it differs on how you regulate them, and here's why. When the state passed their statute in 2023, they consider storage of electricity or battery storage as part of a wind and solar project to be regulated under that same regulatory scheme that they passed back in 2023. So you're confined to that regulatory scheme that the state put out when you're going to govern a battery storage project that is part of a solar project. So you could not be more restrictive than what the state allows you to do if that battery storage is part of a solar project. So, and the reason that's important is you have more discretion or leeway if you're going to regulate a standalone project because it's not part of a wind or solar project. But if it's a battery storage that is part of a wind or solar project, you're confined to that same regulatory scheme that the state set out in 2023, which is important because you then you couldn't increase setbacks, for example, for the battery section. You wouldn't be able to do those types of things if it's part of a solar project, which that's just how that statute was written. Any questions about that part before I dive into sort of these differences that are kind of listed out here? Okay.
What's the cost? I did some research on the internet on the cost of the BESS. Usually 10 to 12,000, is that correct, to put one in?
In that you're probably talking about a non-commercial project. If you're talking about battery storage in terms of to support, say, a commercial building or at somebody's house, it's probably where it is.
It was referring to a building.
Yeah, so that type of BESS system is, you probably already have them in the county, to be blunt. They're probably already here, they're at people's houses, they're at people's commercial buildings. Typically, most counties are not regulating that type of battery storage.
Okay.
It's the larger ones that are utility scale designed to support either grid operation or a solar or wind project.
Are you familiar with the one at Kansas, Illinois, the big one over there?
I'm not familiar with that one. There's one that went in up in Marengo.
Across the road is a Amron substation, So if they have that, they wouldn't need a battery storage system, would they? They simply put the energy over to the substation? Is that correct? Would that be correct?
Not necessarily. So they may still want or need a battery storage component because when you're sending it through the substation, it's going out onto the grid.
Yeah.
When you're storing it, you're essentially, hey, the demand is not there for this electricity at this time, we're gonna store it and release it later is essentially what's happening.
Also, I don't know if you're Miller Grove, they put in a big system right before we get to town. And they have a lot of, looks like things in front, next to the highway where it's like a fuse, looks like a fuse box, like 6 or 8 of them.
Mhm.
Would that be something involved with the storage system, or is that just a way of transferring energy somewhere?
It depends on what it is. There are a number of electrical controls
Yeah.
that are on a solar site, so it could be that, or it could be some sort of small battery storage.
Yeah.
Typically, when you're talking utility scale battery storage.
It's right before we get to town. It probably surprised Energy to the whole town. I'm not familiar with it, but they just put it in. It's a very large system, so.
Yeah, typically when you see a utility scale battery storage project, typically that utility scale project, it's gonna look like a little bit smaller version of a semi-trailer.
No.
And there may be
I just
100 of them.
Yeah, thank you.
So, let me walk through a couple differences between your current solar ordinance and the one that we have drafted up. And they're really, frankly, your solar ordinance actually looks fairly decent. And there's just a couple suggestions I would make to get that where you want it to be. One aspect, I'm just gonna take this comparison, one-page comparison that I circulated to you. So, right now, your ordinance does not include the application of what we call the LaSalle-Sinclair factors. So, and it is entirely up to you if you want to include those or not. What the LaSalle-Sinclair factors are is when the Illinois courts review a zoning decision by a county, they typically apply what's called the LaSalle-Sinclair factors. And there's a number of what those factors are. But the big ones are, is the project gonna impact health, safety, and welfare of the community? Is it gonna have some impact on property values? Those are kind of the big two that would be included. What I will tell you is, when the citing statute passed, us lawyers that deal with that issue every day, all of us kind of looked at each other and went, do the LaSalle-Sinclair factors still apply because they're not listed in the actual statute? At the end of the day, I take the position, I think they do still apply. You wouldn't be able to apply them in a more restrictive fashion than your ordinance, but, or what the state guidelines are, but as long as we're not doing that, I think they would still apply. Now, it's up to you whether you want to include them or not. If you don't include them, it 100% will not be part of your ordinance, in which case you wouldn't be considering those aspects in relation to an application when it comes before you. Now, but it's up to you, and we can always have that discussion. It's not something you need to decide today. But if you look at, I think it's on page 15 of the draft ordinance, we walk through what those LaSalle-Sinclair factors are. And those are, LaSalle and Sinclair just refers to 2 cases that address those issues. And I usually recommend that you include them. But again, some counties, I have had counties say, hey, we don't want to include the LaSalle-Sinclair factors. We want to make this a check the box. And if that's the case, that's totally fine. And it's entirely up to you whether you want to utilize those or not. There are a number of what I would say are technical requirements that a developer has to meet when they come in on an application. Those are things like they have to be compliant with your setbacks. They have to have sound limits have to be within the Illinois Pollution Control Board. Any number of, they have to show compliance with the National Electric Code and things like that. All those things would still apply. The LaSalle-Sinclair factors is just a factor test that the Supreme Court has used in reviewing zoning decisions. There's an open question whether that still applies, because the statute's so new, there hasn't been any case law about it. But entirely up to you. Again, you don't have to decide it today. It's just, I included it just because most counties do include
Are
it.
they subjective factors?
Um,
And it doesn't leave us more apt to be challenged in court?
you would be more apt to be challenged because there is a gray area to that. They can be somewhat subjective, you know, most of them,
It looked like it.
yeah, they can be subjective. They're not, in their application from the courts, they're not really designed to be subjective, but they really, it comes down to that.
At a local level,
Yeah.
they would be.
And so when you talk about things like, is something beneficial to the health, safety, and welfare, comfort, and morals of the community?
He may think it is,
Yep.
I may think it is.
Exactly. And so in the real world application, even though the law doesn't, the way the Supreme Court looks at them is they're not supposed to be subjective, but they really are, when it comes down to it. It really comes down to sometimes does one person like it or not? And that sometimes is a subjective viewpoint, for sure. Now, again, you don't have to include them. In your old ordinance, you didn't have them. And so, and you may decide, hey, we don't want to include them because it just makes it a little more complicated in how that process all works.
And it's these right here, right?
Correct, yes, sir. 1 through 7, yep. So that's probably the biggest thing that you'll have to make a decision on whether you want those to be part of an application or not. Doesn't matter to me if you do or you don't. If though you don't, it's really gonna be a check the box. If an applicant comes in and meets all the requirements, then they've met the requirements. And what the state statute says is if they meet the requirements, you have to issue their permit. To special use permit. So it does make it simpler on your guys' end if you do that, but entirely up to you. We've done it both ways. Your current ordinance again does not have them in there. And so I just want to include them in there. If you do want to include them in there, I just wanted to make you aware of that. Okay, any other questions on that particular aspect? Okay. If you look at page 4, one thing we've included is that it would restrict a solar project to either agricultural or industrial use land. So solar could really pop up just about anywhere. You might have land that's used residentially that somebody could put it on. Typically, projects that are a commercial solar energy facility are not gonna pop up in a residential area just because there's not enough space. But most counties restrict the utilization of their land within the county for solar projects or wind projects, but that's a different story. Solar projects typically are restricted to those that are utilized for either industrial or agricultural uses. That's one thing I put in there. You don't have to do that. It's entirely up to you if you want to allow it beyond those borders. And again, you're not zoned. So if you're not zoned, you don't have a zoning map. So it might be a little bit difficult sometimes to determine whether or not that parcel is strictly an agricultural parcel or strictly a residential or both. But this would propose to restrict that to agricultural or industrially utilized properties. But again, up to you. If you want to not have that restriction, you don't have to.
If we can't define what residential is, then it wouldn't really do any good, would it?
It might, I mean, it could be one of those if a parcel is, and again, this would be a little bit unusual on the commercial solar side. But on the commercial solar energy side, which is only what this is regulating, this would not regulate behind the meter projects that are simply providing electricity to somebody's house. But it may be difficult at times to make that determination. Typically, these projects, you don't typically see them on a residentially used parcel. They're almost always gonna be on an agricultural or an industrial parcel that has enough space for it, just because space-wise, there just isn't enough space in most residentially used properties. So 9 times out of 10, it's probably not gonna make a hill of beans or a difference really to any of it. So, and your current ordinance doesn't restrict it. So, and that may be a reason to say, hey, we don't want to necessarily restrict it here. And I'll tell you, probably most of the projects you're gonna get are gonna be on somebody's agricultural field. You know, the landowners decided, hey, I wanna put this in solar, and they decided that's the best use for that property for them, and so that's what they're gonna do. It, not normal for it to be on a residential property. Go
I
ahead.
know that the one company that I've had conversation with, they indicated, like out of Vermillion, I mean, the landowner that they've got leased to owns ground in the village of Vermillion, but they said they don't want anything to do with anything in a village or city or whatever, so that would basically mean it'd be all agriculture ground.
Yeah, in fact, I think ever since I've been involved in wind and solar projects, I've only seen one, maybe two projects that were not on either ag land or industrial land, just because space-wise, it doesn't work.
What's in, you said commercial or industrial, what would that be?
Like an industrial used property,
Like the airport over at Indianapolis.
yeah,
No, okay.
yeah, good example, yeah. Yeah,
Would that restrict us from using,
Nope.
giving a permit to government, or not government, but somebody who's gonna lease the ground government,
that would not cause an issue.
all right.
And again, this isn't necessarily anything you need to decide today, but if you want to restrict it to just agricultural and industrially used properties, you could. But I'll tell you also, the chances of that really becoming an issue is probably pretty low.
Okay.
Most projects that you see on commercial solar energy side, and there's a big range, so most of them are going to range from about 15 acres on the very small side to, we just had one down in Pulaski County that was, I think, 3,700 acres. And so it's a wide range. Of course, you're not gonna find 3,700 residentially used acres that you're gonna use for that function. It'd be hard to find 20 acres that are residentially used for solar. It's typically almost always looking at agricultural.
Right.
So that's in there just because most places put some restriction on that. You don't have to though. Like the chances of that really becoming a problem are very low. If you look at the ordinance as a whole, there's a few things on your solar ordinance. Now remember, if it's part of a solar project, we have to regulate it under our solar ordinance. We can't infuse two ordinances on them, one being battery storage and one being solar, and force them to apply under both. That would be A, logistically a difficult thing to do, but B, because of the way the state statute is, if there's battery storage as part of a solar project, it would have to be regulated under your solar ordinance. So we did include a few provisions in your ordinance that kind of regulate that process. We can't change the setbacks. So it oftentimes becomes a question of, hey, we want to impose longer setbacks on the battery section as opposed to the solar section. The state statute doesn't really allow us to do that. So we are stuck with those solar setbacks that are promulgated by the state. It's 150 feet from a non-participating residence, it's 50 feet from the edge of a right-of-way, those kind of things. We can, though, impose some requirements if there is battery storage as part and parcel of a project. One of the things we can do is we can have some safety issues built in so that when it comes to battery storage, there may be some risk of a fire, right? And there was a large fire out in California on a very large battery storage facility, and it was a difficult situation to deal with from an emergency management standpoint. Now, we can put in some things to help reduce that risk. One would be we have to have combustible material cleared away from those batteries. So in the ordinance is a provision that just says you have to have a 20-foot buffer around those battery storage units that is either gravel or concrete so that there's no combustible material around that. So that's one thing that's sort of drafted or crafted into the ordinance to help with that. Any questions either about how that interplay works between battery and solar, or it's a delicate thing, and so there is battery storage as a part of it, but we have to regulate that under the state statute. guidelines.
That to me sounds kind of odd because they're two different animals.
Yeah, yeah.
Just because you got a relatively safe solar collector, and then you've got batteries, which is a whole different thing, and the liability to me is quite a bit greater with battery storage. But it regulated the same.
Well, two things to keep in mind. Because of the way that state statute was crafted, it kind of ties our hands in that regard, because battery storage is considered a supporting facility, which is specifically listed in the state statute. So we don't exactly regulate them the same. We just have additional requirements we can impose. Now, the other thing to keep in mind is, which is not uncommon, when a project comes to you and goes through that hearing process, and you guys look at it and decide what you're gonna do with it, the county can always impose conditions in support of its ordinance. So, to the extent, oftentimes, those conditions may be 20 different provisions of, hey, we want these specific things to be followed. And some of them could potentially impose some regulation on how that battery storage is operated, whether it's emergency response, for example. So oftentimes what we'll see is, most ordinances have some emergency response provisions in them, your guys' did, in terms of working with local fire protection districts to come up with an emergency response plan. And so when it comes to solar, there's usually some provisions that we want them to work out with the fire district. It might be equipment, it might be, where the entrance is gonna be, for example. When it comes to battery storage, that kind of gets heightened a little bit because the risk of fire is increased. The way we normally deal with that then is there would be a specific condition that deals with developing an emergency response plan that might even include, how is a fire suppression system going to be utilized at the site. That's not a giant issue when it comes to solar, but when it comes to battery storage, you might want to include a provision of, hey, we need some sort of fire suppression either at the site or what's the plan for water usage that might be there. That's just a very 10,000 foot view of how you might regulate that by a condition rather than vetting it all out with an ordinance. Because what you may see is, you may see a solar project come in and say, hey, we've got 20 megawatts of solar and we have 2 megawatts or 5 megawatts of battery storage, which isn't a lot of battery storage. On the flip side, you might have a project come in and say, we have 150 megawatts of battery and we have 150 megawatts of solar all on the same project, all interconnecting through the same substation. Okay, well now we might need some more beefed up. And that's part of the challenge. Part of the challenge when it comes to solar is the state siting statute for that regulates them all the same. So if it's a 3,700 acre project, like I just mentioned before, or it's a 2 megawatt project, it has the same guardrails that the state has imposed on the counties. And so they all get regulated from the state statutory scheme and your ordinance the same way, but you might have conditions you might want to impose on the 3,700 acre project that would be different than you impose on a 2 megawatt, 14 acre project. So it is different. They are different systems, but the battery storage, if it's connected to a wind or solar project, is essentially storing electricity off that solar project for then release later at a later time. So, but we can always deal with that. We've had a number of battery projects that have been part and parcel of a solar project, and there may be something where we need an additional engineering review on a project. So oftentimes when a project goes through the process, we may say, hey, because of the technicalities involved with this particular project, we want a third-party engineer to review it before you get your building permit and determine whether there's any additional regulation that needs to occur. And then the developer then essentially reimburses the county for an engineer review from a third party. Any other questions on that particular issue? Let me jump to a couple others. So on page 7 of that ordinance, we did put in, again, same thing, it's up to you if you want to utilize this. would be an evaluation for noxious weeds. And this just depends, some counties don't have as big of an issue with noxious weeds as others. Some counties, it's a very big issue, to them and their farmers, so, you may want an evaluation for noxious weeds, before the project comes back for a building permit, for example. So, that whole process then, they would have to present to the county a noxious weed plan or weed management plan to make sure that there isn't noxious weeds that sprout up on that property, especially things like water hemp that can spread to another property pretty easily. And so you may want to have that.
Like maintain a herd of goats.
Yeah, that's right. Yeah. And so that's one reason, that's the rationale behind that issue. We've had that issue pop up in other counties, and that's where the genesis of that came from. A couple other things is, on your fee schedule, right now your fee schedule it doesn't have a refundable provision to it. Here's how typically this works. Typically you're gonna charge a certain fee. It might be 5,000 a megawatt, it might be a flat fee. The intent behind what we would call a special use permit fee is when you, the county, are evaluating that, going through the public hearing process, there's gonna be some costs that you're inevitably gonna incur. Either through hiring an attorney to help walk through that process, it might be an engineer to look at it. And all those costs are, as long as they're reasonable, it's okay to incur those costs and then take that out of their application fee. But at the end of that, you may not use all of that fee. Well, as a county, you can't have, you're not a profit-making venture, and so whatever is unused from that special use permit fee would have to be refunded back to the developer. You could charge a flat fee, and then just keep it, but the concern would be either A, you're gonna charge too much and you end up making money, which you're not supposed to do, or B, you're not gonna charge enough and you're gonna end up on the short end of the stick. So if you charge a fee, what's proposed here is it would be $20,000 for an application. That would cover the first 4 megawatts, and then it's $5,000 a megawatt after that. But the key to that, though, is you have to be able to refund what's left over, otherwise you're gonna have an unreasonable fee at the end of the day. And it would be up to the developer. The developer gets approved for the project, they could always kick the remainder over to a building permit, to apply to the building permit, or they could say, we just want that money back, for whatever reason, which sometimes they do. The other aspect is right now you don't have a building permit fee in your ordinance, and that's okay if that's the way you want that. But you may want to have a building permit fee in, so the building permit fee we put in was $5,000 a megawatt.
And no max,
And no max.
so that would be, if you had a 200 megawatt power, solar power is putting in, that would be $1 million.
Yeah, and you may want to consider a max. So, and I didn't put a max in there just because I don't know where you guys sit on that issue. You could put in a max, especially when it comes to a solar project. Wind projects take on a little bit of a different life. And so the fee's generally gonna be a little bit higher. But your building permit fee is designed to make sure your costs are covered during that life of that project. And so on a solar project or battery storage, or solar project or solar that includes battery storage, you're not gonna have as much cost probably as you would on a wind project. So you could put in a max fee. You could say it's 5,000 a megawatt up to 500,000 or 250,000.
Because the max on the application is 250.
Correct. Correct. Yeah.
Which,
I've only had one project where the application fee, where we've exceeded 250, not just us, but the whole hearing process and getting through that whole thing exceeded 250,000. It's exceptionally rare. So 250 is probably a reasonable number for that. The building permit, though, you're talking about a 30-year lifespan of a project. So you wanna make sure you're not getting shorted. Now, keep in mind, you do get tax funds off of a project too, once it's constructed and operating. So you may wanna consider a max to that number. And if you want me to propose one, I can, but it's up to you guys. Right now, you don't have one in your ordinance.
So the purpose of the two fees is very different.
Correct.
And if our ordinance includes language that for the life of the project, if there's an issue, then it is, if the cost is incurred by the project owner, is there a need for the building fee?
Not necessarily.
Because it is in there.
Yeah, there's a provision in that, in your current ordinance and the one that's proposed that essentially says, if the county incurs any costs in the future, those costs can be invoiced back to the developer, and they have to pay that invoice. So you could do that and utilize that essentially, and then you could either have, if you want, wouldn't have to have a building permit fee if you didn't want one, or you could you could have a lower building permit fee, or a max, however you guys want to do that is totally fine.
If we have one in there and the developer goes defunct, then the building fee cost, permit charge could be used for some of that end of life cost.
Typically, that would fall to decommissioning. So separately from the issue of citing the solar project and your building permit fee is a decommissioning agreement and decommissioning cost estimates that the developer would have to negotiate or work through with the county. So when a project comes through, you go through just the lifeline of it. Usually they file their application. You guys would hold a public hearing. If you approve it, it then goes to what we call building permit phase. So when you approve a special use permit on a solar project, it's not like the next day they're out there starting to build it. Before they can start building it, they would have to come back and get a building permit from the county. Now, right now, you don't have a building permit structure, but we can always build that in. It essentially is just certain requirements would have to be met before they get their building permit. But that is just to check the box. If they meet those requirements, you have to give them that building permit. Separate and distinct from that, or let me back up, one of the conditions to getting the building permit would be that they have a decommissioning agreement with the county, which is already in your ordinance, your current ordinance. That decommissioning agreement and the financial assurance related to that, all would have to be put in place before their building permit is received. So the way that works then is if the special use is granted, and before they come back for a building permit, we would sit down and work out with the developer, with your engineer, your whatever third-party engineer you'd want to use, and the developer, and we would come up with make sure their cost estimates are correct, and then we come up with a decommissioning agreement, and then a financial assurance that has to be posted for the benefit of the county. That whole decommissioning financial assurance, the whole idea of it is, if the developer goes defunct sometime before the end of the life of the project, before they naturally 30 years later, the county can capture those funds either through a bond or a letter of credit or some financial instrument like that. And then they take the funds, the county takes those funds, hires a contractor to come out and remove the project out of commission. And essentially it is, what's the cost of removal and how is that gonna work is all negotiated into the agreement. There's fairly standard processes for all that. A lot of it is governed by the agricultural impact mitigation agreement that they have to sign with the state. But then, once you the idea is that then those funds are captured and used for decommissioning. Now that is a separate financial assurance from the building permit. The building permit is just covering your thought is that it should be covering what your costs of managing that project will be for the county. Services, roads, things that may relate to that. Now, if you don't have to necessarily have a building permit fee, and so that's up to you. Or you could cap it. You just have to, under the state statute, it just has to be a reasonable fee, is what it says. Now, what's reasonable? It's very hard to project costs for 30 years of a project. But if you're comfortable with the idea of, hey, we have a decommissioning bond or letter of credit in place, we don't necessarily need to worry about a building permit fee off of them, or a very large one. So then, you wouldn't necessarily need to put in a building permit fee. Right now, your ordinance does not have a building permit fee.
I'm still trying to think of, because I'm sure there are reasons to have a building permit fee. You know, if they are required to submit an annual report and they don't, then of course we'd be relying on our state's attorney to get involved. But if they, and this is more wind, I guess, than solar, but just theoretically, if they fail to, if they damage our roads,
You could have that. Typically, in your current ordinance and in this one, the developer would have to get a road use agreement before they get a building permit. So when they construct the projects, and it really can depend on the size, and it's very different than wind. Wind project, you 100% have to have a road use agreement in place, because A, almost every load is overweight, and B, almost every load is oversized. So you gotta bring in cranes, the wind turbine blades, the actual tower pieces. On the solar side, a very small project probably is not gonna have much impact to your roads.
I was
On the
trying to
larger
think of
side.
something that within the 30 years, theoretical 30 years of the life of the project could result in
Costs?
Costs.
Yeah, you would, couple things you might have. You might have an engineering inspection. Some counties have a third-party engineer go out and inspect the solar site annually. Sometimes it's every 3 years, to make sure it's still within code requirements, that it's working and operating correctly. Most developers do a pretty good job of making sure that their projects are operating, because there's so much financial investment that's involved in it. So you could have that. You might have a road issue that comes up after the road use agreement. Usually the road use agreement on solar projects covers only the construction period, and not necessarily the whole operational period of the project. So you may have some road damage. It would be a little bit unusual to have a significant amount on a small solar project. On a larger one, feasible, just based on the number of inverters and things they have to bring in. Or you might have an enforcement issue. Say you have to have somebody study a sound issue at a solar project, and you have to go out and hire a third party to then go enforce that sound provision. So you could have, it's hard to really predict all of them that may come up. You may have an enforcement issue that your state's attorney says, we don't have time to deal with a solar project right now, because there's other issues, of course, that your state's attorney has to deal with. So you might have to hire a third-party engineer or an outside counsel to deal with it. But when it comes to building permit, right now you don't have one. I would suggest at least having some building permit, even if it's on the smaller end. You know, you could say, a fairly reasonable one would say, hey, it's $5,000 a megawatt up to a cap of $100,000 or something like that. And then if you get a 20 megawatt facility, they would hit the max. If you have a 200 megawatt one, they would still be paying just a $100,000 fee. And keep in mind, you can always go back to them and say, hey, we've got some costs we're gonna have to incur in either looking at an annual report or doing an inspection, or we have a complaint that we have to address, so we're gonna have costs associated with that. You can always pass that back to the developer if you incur a specific cost for it.
On page 15C, it does say additional costs noted above, and if you added something in there to the effect for the application time period, the permitting, and the life of the project, they're required to pay, but not limited to,
Correct.
all the things you've just talked about.
Correct.
I still think it makes sense to have a permit, period, for at least as long as that works, a nominal amount,
Right.
so that we have some organization to the process.
Yeah.
If that, with nothing else. I mean, whether it's a $5,000 fee or whatever it is.
Yep. And then also then you're not chasing a developer around to get reimbursed if that occurs.
It's more direct, and I think it lays things out more methodically
Sure.
about what happens, and
Yeah.
this has to be done and this has to be done.
Yeah.
I mean, that's my opinion on you guys.
Yeah. And you mentioned on the decommissioning, you said that, you know, they have to put up a surety bond or something. And then the county would be responsible for seeing that it was cleaned up. Does it ever revert back on the landowner, the original, you know, the landowner, that he's responsible?
It can, so they can, under their, it may depend on what their lease terms read as.
Right.
But typically, you could go back to the landowner feasibly if it needs to be cleaned up in the context of, hey, there's no energy being generated here.
Mm-hmm.
Most counties don't have a specific requirement for that. And so it typically, the other part of it is, when you're dealing with landowners, oftentimes what happens is, or what is going to happen, somebody signs up their land into a solar project, and then 30 years later, the person who signed that project in with their parcel has passed away. And their kids may be the ones who are then managing that property either through an estate or, and it may get very scattered as to who actually owns that property. To avoid that sort of confusion of it all, it's much cleaner if the county has at least some funds that they can call on to do the decommissioning. And that's essentially how the agricultural impact mitigation agreement is structured. So when they go for a project, they have to sign that with the state. They can't get a permit from us until they have that signed and executed. So then, as part of that is their posting requirement to the county for those decommissioning funds. There are provisions in the AMA that are essentially, the whole idea of the AMA is guided towards protecting the landowner from a developer who walks away. And so there are provisions in there that are designed for that protection, but then the financial assurance is posted to the actual county. So, and that's how it's just structured, and we are tied to that structure under the state statute. So the state statute ties us to the AMA in terms of how we regulate decommissioning. Before the state statute, it was very much, we could impose anything really we wanted to do on decommissioning because we weren't restricted. There are some provisions in the AMA that deal with both the landowner and how that financial assurance is posted. Any project that occurs in the county, even if it occurs in a municipality, they're supposed to post the financial assurance to the county, which is a little bit unusual.
And who decides on the amount that is? I mean,
It typically, when a developer comes in their application, they're gonna have to have some cost estimate.
on cleanup.
Yep, on how much the cleanup would cost. And then sometimes the counties just say, okay, well, we agree with that, or that looks good to us. Or often what happens is the county tells me we need a third-party engineer review. And then we engage a third-party engineer. They go through that cost estimates that are being done or proposed by the developer and make sure that those cost estimates are correct. And sometimes they're off. Sometimes they're usually not off by a lot because their decommissioning plan and cost estimates are typically done by a licensed engineer anyway.
Okay.
Now, there's always room to quibble. Okay, we always have some disagreement on here or there, and that all happens after the public hearing and if the county board were to approve a project. So if you approve it, one of the conditions of them coming back and getting a building permit is they have to go through this negotiation with the county. And that decommissioning agreement, two things, decommissioning agreement and road use agreements all come back to the county board for approval. So you don't want me deciding whether that's correct or incorrect, or whether the terms of the road use agreement are in your best interest. We'll negotiate it, and we'll get to sort of a tentative agreement, if you will, and then we bring it to the county board and say, here's the proposed agreement, we're good with it, your engineer's good with it, so it's up to you then to approve it. So that cost, typically what you would see on a community solar size project, the cost estimates usually range somewhere between about 300,000 to 500,000. And every once in a while you get one that's a little bit on the low end, and I go, you guys need a third-party engineer to look at this too.
And that's on like a 200 megawatt roof.
That would be on a community scale one is about 5 megawatts, 5 megawatts and less. So on a larger one, that decommissioning cost is gonna be much more.
Okay.
I was thinking, or had, maybe it's on the wind one only, that we revisited it every 10 years.
It does, and here's what I would tell you on that. The decommissioning agreement, or the decommissioning financial assurances, the way that AMA is structured and is one of the issues that kind of lingers out there is this. The AMA, Agriculture Impact Mitigation Agreement that they signed with the state, you revisit the cost estimates at year 10, and it's up to you if you want to revisit them after that. It would be year 10, 15, 20, 25, 30, and that's kind of how the AMA has it structured. Now, there is a provision in the AMA that says a county can impose additional requirements beyond what's just strictly listed in the AMA. But we have to be very careful about making sure it's a reasonable requirement. Some counties say, okay, fine, if you want to do it at year 10, 15, 20, 25, that's fine. I would suggest we revisit that a little more often. So we could revisit it at year 5, for example, and then year 10, 15, 20. Part of the reason is that AMA's financial assurance structure is staged up over time. The theory being is that projects are unlikely to go fallow in the first 10 years. So the way the financial assurance structure works is in the first years 1 through 5, they have to post 10% of what the decommissioning cost estimate is. In year 6, it bumps up to 50%, and then in year 10, it bumps up to 100%. I'm not entirely sure why they did it that way, but the theory behind it is, from what I understand, is that the likelihood of a project going fallow in that first 10-year period is very low. So the thought is, hey, the developer doesn't need to post that whole amount from the get-go under the state's theory. And so we let them stage it up, they let them stage it up over time. Now sometimes in our decommissioning agreement is where we spell out the frequency with which we want that decommissioning plan updated. So when we do rather than spelling that out within the ordinance, which might tie our hands, the better option for us is to have it by agreement, because there may be projects where you say, it's a 2 megawatt facility, it's 14 acres. You want to update your plan at year 10, fine. We're not too concerned about it. If you have a much larger facility, you may say, hey, we want to revisit this every so often so we don't get caught in a bad situation. And so you may want to revisit it more often then. Or you might have a developer that's very new. As you can imagine, this commercial solar world is a little bit of a gold rush going on in Illinois right now in that world. And so you may say, hey, you've got an established long track record with your business of building, constructing, and operating projects. We don't necessarily need to review your project every 5 years, or the cost estimates. But you may have somebody else that is very new. They came into being 5 years ago or 2 years ago, and there's not necessarily that established track record. You may say, hey, we want to look at this project more often, the cost estimates of it. So yeah, that's why I didn't include the actual frequency with which we do it, is because might want to have that flexibility to do that within the context of the agreement.
So how does that work if it's not spelled out in the ordinance? Where's the agreement come in, and where's the mechanism for that?
So the decommissioning agreement would occur before they would get a building permit. So what happens is, let's say they apply, go to the public hearing, county board approves it, hypothetically, county board approves the project.
If
If
the
they,
building permit, yeah.
yeah, and so you're not yet to that building permit stage, so they can't build anything yet. So then between that special use granting by the county and before they come back for their building permit, in between that period, which sometimes is a period of a year, sometimes more, there is a negotiation between the county and the developer as to a decommissioning agreement and what those financial assurances are gonna be. And we will, you know, there's somewhat of a standard form now, although there's always some special issues that may arise from developer or the county may want to address on a particular project. And in that agreement, once we get to some reasonable, us, the engineer, might be somebody from the county board that assists in that negotiation back and forth. Once we get to the sort of a tentative agreement, we then take it to the county board for approval. They can't get a building permit until that's done. So they can't build anything until a decommissioning agreement is in place.
And a road use agreement.
And a road use agreement, and a weed management plan. So those, there's a number of other conditions they'd have to meet too, but those are like the big two issues are decommissioning and road use. And so then we spell out within that decommissioning agreement, all of the things we want them to do and how often we want them to revisit it. You could put that in the ordinance, but I wouldn't necessarily suggest it because it confines you to following then what your ordinance specifically spells out. And you may want flexibility from project to project. You may have, you know, it's a little different than the wind world in that wind projects, you're usually talking about projects that are gonna be somewhere between 200 megawatts and 400 megawatts. And there's some that are kind of being in the works right now that are even more than that. But there is a pretty defined world, like you're not gonna get somebody doesn't come in and build one turbine. That doesn't happen. The solar world is a very vast world when it comes to commercial solar projects. And some of them you're gonna wanna review more often for various reasons, and some you may say, we don't need to review your project that often. So that kinda gives you that flexibility. If you wanna put that in a hard and fast into your ordinance, you could, which is how you have it now. But typically I would, on the solar side at least, you wanna have some flexibility to that.
So if we're gonna add a permit to this, it's not in there, in the one that you just handed out. Permit.
Building permit,
Building-
it is.
It is.
But it's not spelled out.
Right.
In other words, what you need to do before you get to the building permit.
It is. So, like, for example, you need to have your road use agreement in place. You need to have your decommissioning agreement in place.
Okay, that is already in
Yeah.
the one you submitted. I
Yeah.
thought you said you could.
No, you're good. It's listed in there, you know, before you get a building permit. Oh, you're okay. Before you get a building permit, you gotta do X, Y, Z.
Okay.
Now, oftentimes what I'll tell you is that typically you're gonna have conditions on top of that. That would be, hey, we also need, you know, let's take an example. Really large project, a solar project. You're gonna say, hey, before you get a building permit, we want you to have, example, a website that explains to the public what the construction staging is gonna be, so that they know what roads are gonna be impacted. Small project may not need that, because there probably isn't gonna be a big impact to your roads. But on a very large project, solar project, you may say, hey, we want you to have and maintain a Facebook page that is updating the public every week about what roads are gonna be impacted, where the travel's gonna be, hours of construction, things like that.
What's a large project?
Typically something that's over 50 megawatts. So 50 megawatt project would be about 300-ish acres, somewhere in there. When you get to that size, you're usually dealing with multiple parcels, you're usually dealing with multiple roads and multiple entrances on those roads. So so it has a little bit of a greater impact. When you talk about a delineation in the state and how they look at projects, all of these are commercial solar energy facilities. So anything that is a megawatt or more, you can see, like, we've had projects where it's 1.8 megawatts is the proposed project, and it's 12 acres. Very little impact on your community, right? But all the way ranging up to a 405 megawatt project and 3,700 acres, which has a huge impact on where it might be. And so that's why in that solar world, we typically say we need a little more flexibility to deal with the project that might be coming in. Whereas like on a wind project, you are always gonna have a road use, you're always gonna have decommissioning agreements, you're always gonna have building permit fees that might be pretty significant. Whereas in the solar world, it's just such a wide range of projects that you might get. And some of them you might impose, 20 additional conditions on them of approval. Some of them you may not impose any other conditions, you just say, have at it.
Sounds like the majority of everything in here is already, it's the state and, like the AMA, the agriculture thing, it's all, there isn't a whole lot we can do to change that. Is what part of it, of this agreement, do we have a little bit of flexibility on?
Do you mean in the decommissioning side
Well,
or
just
on the?
any-
Emergency services.
Yeah, so
Emergency services?
that's a very good example.
Yeah.
So, emergency services is one where we typically have some very specific provisions,
Mhm.
conditions of approval.
Mhm.
So it may not be all spelled out in your ordinance, but like, for example, in your ordinance now, and in this one, is an emergency services provision. Essentially requires them to go give their plan to the fire districts,
Right.
work on an emergency response plan with those
Mhm.
fire districts and the county EMA.
Mhm.
And then before they get a building permit, they'll have to have that response plan in place.
Okay, all right.
But then, on top of that, you may get specific projects where it's, hey, we need a little bit more, emergency services. And so you may have a special condition that might deal with, water usage or,
Yeah.
reimbursement of emergency response costs,
Right.
things like that.
I know the one company that's in here now, they've already met with emergency responders and, kind of letting them know, and they had a presentation on battery storage,
Yeah.
on fire suppression, stuff like that. So,
Yeah.
they're working with, letting them, trying to keep him
Yeah.
informed on what to expect.
Yeah, those are all indicators of a good developer,
Mhm.
when they come in and they say, this is what we're planning to do, but we
Mhm.
wanna talk to you guys about how
Mhm.
this is gonna look. And
Communication.
Yeah,
Right.
and so those are all the indicators of a good developer.
Mhm.
We have seen situations, and it typically is on the smaller scale projects,
Mhm.
where they come in, they don't talk to anybody, they just drop an application in the county's lap, and then nobody has any idea what's going on.
Mhm.
Um,
And that's what happened with the one in Kansas. We finally just met
Right.
with them this
Yeah.
week.
Yeah. And so, that's, the things you're mentioning, all good signs. They'll come to county board meetings, they'll work with those fire protection districts, because they're trying to become,
Yeah.
A part of the
They've met with township
yeah.
officials and, they've come to some of our meetings and stuff.
Those are all good signs.
Yeah.
We've had projects where you have a very new developer, they don't know necessarily the state requirements, they don't necessarily know the ordinance requirements, they just come in, drop an application in the county's lap, and you're sitting there going, who are these people? I've never even heard of them before. Conversely, the better scenario is they come in, they talk to the county board, they talk to their fire protection district, they talk to their township road commissioners, and work with them to come up with a plan that works. And that's what you wanna see.
Vern, did you have a question?
I did, just like Carl just mentioned, most of these things are already in place, more or less, guidelines. Is there, and you mentioned the very first, some counties are already zoned. Is there a Macon County or something, we can just get and tweak a few things, or? what
Yeah.
You are a good, different county, or do you have any split?
In terms of your solar ordinance, the one you already have in place is pretty close. Like there wasn't a ton that I would even suggest to change. The big thing that I think you probably need to wrestle down is whether you want to apply that factored test, which is listed on page 15, there you go. Whether you want to apply that or not, again, you don't have to. That's entirely up to you. The ordinance you have came off, I think the ordinance you used came off of the one that was circulated by the Farm Bureau and the Association of County Board members. which is one we work with them to develop. So you're real close to what you probably want. It's just, these are just sort of, hey, do you wanna have these sort of à la carte items, if you will, of either implying or imposing those LaSalle Sinclair factors, and whether you wanna have a building permit fee, things like that. When it comes to battery storage, that's a unique aspect. If you're gonna have a standalone, I don't know if there's anybody that has come around with a standalone battery project, if you know of. So if you wanna do a battery storage ordinance, I'm gonna say may be able to, but there's a sample I think that you used that's out there circulating around. We probably just need to make some tweaks to it. I do have a version here that you could utilize, but we probably need to have that's a separate animal. So if you've got, somebody comes in with just a battery storage project, it wouldn't fall under your solar ordinance, it would fall under a separate regulation. If somebody comes in with battery storage as part of a wind or solar project, it's gonna fall under either your solar ordinance or your wind ordinance. And so, but your ordinance is pretty good the way it is. You could even just keep it the way it is if you don't wanna change it.
No,
But it's
You
entirely,
know what, you wanna change it?
I want to change it.
Oh,
yeah.
Yeah.
And you can, I mean, you're not bad off with your current ordinance. We can always impose a lot of things through conditions of approval. But, again, I would, if I were to make changes, I would recommend making a few tweaks. But in terms of whether other counties that have done it, you guys have probably an ordinance that looks real similar to other ordinances on the solar side. The battery side, there's quite a few counties that don't have any ordinance. And I can jump into that battery storage ordinance if you want, if there's other questions you might wanna ferret out on the
I
solar
think that
side.
needs to be another day.
Yeah, I've worn you out here. I was like,
No,
But-
it's all been good.
I do want to make some changes, and we had discussed the fact that I felt like we needed to tighten the process, because that's where,
I think, yes.
that's been my big concern all along. And so having the building permit is a great part. We thought we couldn't have it because we were unzoned.
yeah, and that brings up a good question. So one of the big differences between zoned and unzoned, is what your authority, where your authority really lies. I think you can impose a building permit fee. You need to make it a reasonable fee, but I think you can have a building permit fee. The area where it gets a little bit gray in the law world, which is when the statute was passed back in January of 2023, there was all sorts of issues of all the attorneys that work in this world, we go, well, does this apply, does this not apply, can a county do this, can a county not do this, can they impose an additional restriction, or is that considered more restrictive? All questions that are still unresolved because there isn't any court cases on it. So, in my opinion, I think you can impose some sort of reasonable building permit fee, as long as it's a reasonable fee. Most counties, even unzoned ones, do that. The big gray area is whether or not you can impose the LaSalle Sinclair factors. That's the big area where there's a big open question that's still unresolved. And that's just something you're gonna have to decide if you wanna try to do that or not. If you have them in there, arguably you can apply them. If you don't, you for sure can't. But that is all entirely up to you. If you're comfortable with a project coming in, and if they meet your code requirements, absent LaSalle Sinclair factors, then approving it. And there's a lot that we can still impose on them, decommissioning agreement requirements, road use requirements, those are all things that would still apply. So you don't have to apply those LaSalle Sinclair factors if you don't want to. In terms of your processes, I do think it would be good, you can administratively require, or not require, but you could administratively spell out what the process looks like. So if you look at most counties, it almost always follows this process. You have to submit an application within a certain time period, we have to take it up, but you can come up with an application form. We've done a number of forms for counties that essentially, here's your special use application form, developer, you fill it out, and then give us all your supporting documents. There's quite a few supporting documents that go along. So if you get a big project, it's not uncommon to get an application that's 1,000 pages long. Sorry, but, so they tend to be pretty lengthy. And then to the building permit phase, when you have a project come before you, you're gonna have essentially two documents that kind of govern that project. There's your ordinance, and then there's the ordinance that approves the specific project. And then that ordinance is gonna have attached to it, if it's approved, a number of conditions. So between this ordinance and your conditions will spell out exactly how that project is supposed to operate. And then we've done a number of building permit forms for counties where we just give them here's a 2-page form. They gotta check those boxes plus meet all of the requirements that are listed in the conditions and the ordinance, and then they would have their building permit issued. And because you're on zone, that process is unfamiliar to you probably, because you probably don't have, well, I'm sure you don't have a zoning administrator, but you don't have someone whose job it is to specifically do that. And so you can have a county administrator do that, you can have us do that. We can't issue, if you do have us do it, we can't issue a building permit without you saying, okay, like I don't have that authority. They have to come to the county board and say, here they are, they've met their requirements, you just need to vote to approve it. And then you would vote to approve your building permit. And so you could spell that out, that process within the context of the ordinance. It could just be a 1-paragraph, here's what we want you to do, and I could add that in if you want.
That in the part on 15, or whatever page it was, where you say that they're gonna be responsible for the life of the project for any additional fees.
Okay,
You know what I'm talking about? In other words, right now I think it's kind of open.
yeah,
It just says you're gonna be this, we need to have that time now. And that's just my opinion, nobody else can.
yeah. So I can add those two things in, and then I guess 2 questions for you, and again, you don't have to determine this today, but, is if you wanna impose a building permit fee, what do you want it to be? I put in a suggestion, but I would suggest you have some cap to it. Somebody comes in with a 400 megawatt project, they'd be looking at a $2 million fee, you know?
Well,
which
and
is-
the other thing, if they're still responsible for any costs
Yeah,
through the life of the project, that would seem to lower that
correct,
fee.
yep,
I mean, wouldn't it?
yeah. It would. So, those are probably the 2 things, and if you want to include the LaSalle Sinclair factors. And again, you don't have to decide today, but,
Well, we kind of do need to decide quickly though.
okay.
Well, yeah, I mean, we don't want to wait till the summer, but I think if we kind of see what changes you make and within the next 30 days,
Which,
Well-
if it's within the next 30 days, then that pushes us back to June.
Well,
When's
I
our
was
next
hoping
meeting?
we get some direction and we might be able to get it back in about 2.5 weeks.
Yeah, I mean, I can,
If there's, I mean, we're
yeah,
just,
if we could get all our changes made, so we could do something maybe at the May meeting,
yeah, that's the 14th.
yeah.
But we're gonna have to give it a
Well,
little
Well,
direction.
yeah, I guess this is already the 21st.
Yeah, yes.
Okay,
This next study session is 3 weeks from today.
yeah.
is that May 12th?
Yeah. Yeah, May 12th. This is Sunday.
And then here, just real quickly, before you enact an ordinance, as I understand it, it sounds like you have some form of a public hearing, if you will, before you enact them, or you just take it to the county board and they're just passing it?
Well, we'd have a public hearing before we approve our ordinance.
Okay,
Well, we had one already, but we didn't pass an ordinance
On the battery storage.
on the battery storage.
Right.
Well, first of all, do we need a public hearing?
yes.
Okay.
So, yeah, the way, this is a little bit of a unique spot when you're unzoned. So, when the statute was passed in January of '23, you didn't take into account how does an unzoned county pass a citing ordinance, because it really, it makes sense for a zone county because there's a whole statutory scheme that spells out how you pass text amendments. But if you're not zoned, there's this open question, how you're supposed to do it. So what I generally recommend is say, hey, if you just follow the statutory scheme that they put in place for the zone county for passing an ordinance, you'll be fine. What you don't want is just have the county board pass it, because then there's gonna be a question of, was there what's considered due process allowed for people to have input?
Is there a difference between amended and passing a new document?
Not necessarily. At the end of the day, you're doing the same thing.
All right.
So what I would suggest is, you have a public hearing. I'd probably have at least an hour blocked off to do that. And it can be, it doesn't have to be fancy. But typically what we do is when we come to that hearing, we give you, we publish it in the paper ahead of time. There's gonna be a
The whole
hearing.
ordinance?
Well, normally what we'll do is we'll publish notice of the hearing
That's what we
and then put it online. We put the ordinance itself, like if you wanna read it, you can either go to the county's website and pull it up, or you can go to the county and just ask for a copy. And then at the hearing itself, we have to do that 15 days in advance of the hearing. And then we sit down at that hearing, and some of them are very short, and we just go, here's the proposed ordinance,
Yeah,
here's the
nobody showed up
suggestions.
except the company, the
Yeah.
last hearing.
Yeah.
Nobody.
And so then it could be pretty efficient to get through that.
So we'd have to publish, if we were gonna do it on the 14th, we'd have to publish tomorrow.
Yeah.
Well, see, we only have a newspaper that comes out once a week. Comes out on Thursday.
Gotcha.
So that would even work for that.
So today's the 21st, and what you would have to do is, it comes out every Thursday?
Yeah.
Right,
So
Right.
it would work.
Yeah, so you'd be
Be
too
a day
tight
late.
for the 14th.
Yes.
Yeah, unless you publish it on the 24th, which is probably too late to get them stuff now. But I don't know. But if
Well-
you-
She's saying yeah.
But even the
So, yeah.
24th wouldn't be in time. That would
It,
be,
it would be. If you published it on the 24th, you'd have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. It'd be 18 days in
oh,
advance.
okay.
No, it'd be
Hey,
20 days.
Lisa, I guess what's your, you say wait until June, what's your concern, I guess? I mean, we need to make sure it's done right,
Right.
and,
When we've been looking at timeline, we've been talking about May. I'm fine with June, but it's,
I mean, is there any, no one's gonna rush in and,
Well, there's a moratorium on it right now.
on the
there's
battery
not.
storage.
Well, on battery, yeah.
But, no one's gonna come in and fill out an application and have it before we get past it in June.
Well, first of all,
No, but we're talking about the solar one more than the standalone battery. And of course, there is no moratorium on the solar one, because you can't.
Correct.
But, if we wanna do, if we wanna try to do both in June, we could do that.
Yeah, it's up to you guys. Now, I at least recognize one person here who I know represents a developer.
Well,
so-
yeah, I was wanting to see if they had any
Yeah,
Yeah, you may
comments.
wanna
I
see if they
wanted
have
to
an
hear,
issue.
that's what I wanted to hear.
Yeah.
Because if we slow it up by dealing with wind, we wanna get the solar done, period,
Right.
one way or the other.
And the other option, you could always hold a special meeting.
Yeah,
Right, yeah,
absolutely.
right,
Hold a special meeting and
And a
hold
hearing.
the public hearing, and then
And
right
then have
after
a
it, just
special-
hold a
Right,
special meeting.
yeah,
You could always do that.
Yeah.
yeah.
Yes,
Comments?
so here, I'll go first. So my name is Seth Upoff. I'm an attorney from Peoria, like Andy. Handle some of these matters around in other counties and have some experience with this as well. I'm here representing IPA Power. I think you may know Andy, this Andy.
Yep.
Who's been to some other meetings. So in listening to a lot of what's been discussed, as you're talking about specifically the solar and BESS combination ordinance, not the standalone BESS, but this combination ordinance, that's what the type of project that IPA is proposing right now. And so, in terms of a timeline, there are some timelines that developers have to deal with in relation to utilities. So there is a timeline coming up for IPA that they would want to hopefully have a permit approved or near approval by the time we get to the summer. So when you're talking about some of these things, the other consideration to take into account is once you get the ordinance passed, then you have to go through the application. Once the application is approved, then you've got to set it for a hearing. That public hearing would be a little different than this text amendment hearing. I mean, it's operated the same, but you're likely to have more evidence and testimony that's going to be presented there. And I know that Andy hasn't quite gone down that road yet, but when you start laying out the timing, if you don't have something that's in place pretty soon, then it's gonna cause concerns for the developer. Now, you have an ordinance in place, and like Andy talked about, there's a lot of things that you can do with special conditions. So it could be that if you don't wanna rush on amending your current ordinance, there could be an application filed under the current ordinance, and then you could address some of the things Andy's talked about via special conditions through the hearing process. So that's another method of going through it. And I think most of the things that you've discussed, I haven't had a chance to talk to my client yet. We're sure what all was going to be added by Mr. Kite, but sort of anticipating some of that. We've talked about a few things. I think most of what Mr. Kite has proposed wouldn't be objectionable in any way. But I can't speak to that definitively on behalf of my client yet. But I think that if you were just imposing the things that Mr. Kite talked about, I think there's a likelihood there wouldn't be any issues or objections from the developer, so you likely wouldn't have certainly any opposition from the developer at your text amendment hearing where you're amending the ordinance. But then later, once an application is filed and we have a public hearing on the project itself, no telling whether there's going to be opposition from the community or who may show up to want to be involved. So that hearing process can be a little more involved. So if we want to do all of that by, let's say, end of July or August, then we'd have to be moving along. So we're not trying to rush you in any way, but I just want to let you know that there are some timing concerns on behalf of my client. But even if you want to take your time in going through and amending the ordinance, we still could go through the route that Andy was talking about, applying under your current ordinance, using some special conditions to clean up some of the things you want to clean up, and go that route.
If I could touch on that for just a second. So you have a pretty good ordinance right now. Looking at your ordinance, I don't have any concerns about it in the sense of making it work if somebody needs to come in on a project before you amend it. I'm not, in looking at it, I don't have any major concerns. So if you want to go the route of say, hey, we want to amend our ordinance and consider some of these other things that I've talked about, we could always do that and take a project that applies under your solar ordinance and do, as Mr. Uphoff had mentioned, we can always take those issues up, a lot of these issues by condition. The only wild card to it is you don't have your LaSalle compare factors in your ordinance, which is okay. Like, you don't have to have them if you don't want them. And in some ways, just to be blunt, it makes the process easier if they're not there. So it's a very more black and white issue when a project comes before you. Most of the things that we've talked about, we could utilize conditions to handle on a project if they come before.
So we don't have building permit in our current ordinance, as I recall. So if we amend our current ordinance after we have received their application, was it still in place?
Yeah, if you amend it before they come back, you have a building, the way I think it's structured now is your building permit fee. It just says there is no building permit fee, something like that.
That's what I remember.
Yeah, and so if you amend the building permit fee before they come back for their building permit, that new building, whatever your new amendment would be.
But our
required.
current ordinance does say that a building permit is required, because I was thinking it didn't because of us being not zoned. But if,
I can look, now, the other thing we could do is by condition, impose a required building permit. Now, you wouldn't be able to impose a fee unless you're agreeable to it, but, because your ordinance doesn't have a fee in it. You can't make conditions that are contradictory to your ordinance. Like, you can't change your ordinance by condition, is what I'm saying. So you could, if they were agreeable to it though, impose some building permit fee, but keep in mind, you'd have to be eminently reasonable.
I guess my concern is more the building permit process than it is the fee.
You could still do that. You could put in a building permit as a condition. Like, before you come back and start actually constructing the project, you have to apply for and receive a building permit, and here's the requirements for that. And it'd be, like, in that context, you'd probably have a few conditions, road use agreement, decommissioning agreement, things like that.
Okay, because when we did this small one at Kansas, we had that all required before we gave them
The special use.
the special use agreement.
So we passed one in 22, and then we amended it in 23.
Yeah.
I guess what I'd like to know is, when do you need the building permit? Not all this other stuff, in order to make your thing with the utilities.
Yeah.
When do you need that building permit?
Yeah, so I think Seth was speaking to the special use permit was the kind of what we're looking at in the short term, because the building permit is gonna come sometime later after we
Okay.
receive, so the building permit's gonna come later on, and that's not something that we're thinking about right at this second. And actually,
I thought that's what you were. What is the special,
The special use is just taking their initial application and money.
when does that have to be by?
so we would, I was just, and do you mind if I stand up too?
Sure.
Yeah. Hey, everyone, Andy Myers with Public Affairs Consultant with the IPA Power Solar Pole Storage Project. I know I've been at a few meetings with my colleague Ian. Ian had a family matter, so couldn't be here today, so Seth and I are here in his place. So we're the ones doing the solar project kind of over in the eastern part of the county, near Vermillion. And I think to your question, what we'd really like to have, and I was just communicating with Ian over text, we'd like to have our permit, our special use permit, to be clear, in August. Because there are some kind of development timelines that we have to meet in terms of just financial decisions and feasibility. So we'd like to have ideally our project approved in August. And so I certainly don't want to speak for the board or for Mr. Kite, but it sounds like that could be doable if you guys had an ordinance approved in June. We could start
That's what I was
we
thinking.
could start an application process
It would be much cleaner.
shortly after. And again, I want to communicate with Ian a little bit further. We haven't reviewed this ordinance in full. We've just kind of verbally hold this, so I'm giving you kind of a gut check answer. So we'd certainly like to be able to fully review the ordinance and provide feedback if needed. But I think Seth spoke to the fact that I think most things sound pretty good. So pending any specific concerns that would come out of our due diligence of the ordinance, I think that would be a timeline we're comfortable with, tentatively. Does that answer your question?
Yeah.
Okay.
That's,
In terms of
See, then there's no sense in worrying about conditions, and
Right.
we
Yeah.
just do it right the first time.
Yeah, it's cleaner that way, for
Yeah.
sure.
Maybe.
It's cleaner that way. I just was relaying that, I just wanted to relay that your current ordinance
Well,
is
appreciate
workable.
that.
Like, we have some counties where the ordinance is completely unworkable.
We have Lisa to thank for that.
Yeah,
and all of
it's
her
very good.
research.
So you're very close to what you really want. And so that timeline in terms of getting it, did you say August?
That would be great, yeah.
Yeah, so if you passed an ordinance sometime in May, and then they applied sometime in June, your special use hearing would occur sometime in probably early July, mid-July, would be my guess. And it's up to you, I don't know do you have maybe you haven't thought this part through. Do you have a committee that would hear or hold the public hearing, or would it just be before the whole county board?
It would be before the whole county board.
Okay, and that
We're only
makes,
7 members, so.
yeah, so that makes it a whole lot easier, because, in its own county, you go to a ZBA hearing, and then they make a recommendation to the county board, and there's usually 30 days between that period anyway, so you have to hold a hearing within 60 days under the statute. Then within 30 days of the ZBA making their decision, the county board has to vote. But because
somebody building a best system in Edgar County, is somebody getting ready to build a best system?
Just the best system, not that
Not
I'm aware of.
Not in Edgar
So
County.
this would be a combination of solar and battery storage.
Okay.
Yeah, this project.
So the one they're building out in your area, they're gonna build a best system with that, another company coming in?
same kind
This
of.
company,
Same.
same one.
Okay.
It's a combination.
So it's the company that's building the solar farm, also gonna build a bus system?
Yes.
Okay.
Sorry if we didn't.
I didn't quite understand that.
So we
Separate
could
or
have a
together?
special meeting in
Okay.
May later on
Okay.
and not impact the time.
Yep, and you can, because you would be the ones holding the hearing, you can, during that public hearing, once you've heard all the evidence, you can decide and vote on it right there. You don't have to come back and hold another meeting.
Well, that's
That's
what we do.
interesting, yeah.
Yeah, so you could do that, you
Unless
could,
there were issues.
yep, and you could do it at 9 in the morning, you could do it at 6 at night, you could do it whenever you wanna do it, as long as it's,
As long as it-
Yeah.
as long as it doesn't end up.
can't do that
like
part, but,
The wind,
yeah.
Then we can deal with,
yeah.
or if you're ready, but I don't know that you're ready for the wind yet. I mean, it's up to you.
No, but I mean,
No, but we
we
don't
went
have a
through the
lot of
wind
time
thing.
on that one either, because they're still moving forward.
Who is the developer?
No, there are a couple of different ones up on the north end of the county,
Okay,
one on the northwest and one on the northeast.
yeah.
The one on the northeast is pretty serious.
Yeah, so the wind one will, there's a little more to it. And those are, those hearings can go on for weeks on it. Just,
And our ordinance definitely needs work.
yeah,
What about the Sinclair, or LaSalle Sinclair factor for you guys?
Do you have a breakdown of what that actually
Yeah, page 15.
yeah.
is? It, well,
It goes into the next page. There's 7 items.
I do like your thought on having it there in case we needed it, but
Yeah.
I don't know, it's subjective, just doesn't seem to fit well in.
That's what my
ordinance,
thought
yeah.
is.
Yeah, and that's entirely up to you. I mean, you can always, if you want me to communicate with Lisa or whoever you want me to communicate with, you guys can always, talk about it or think about it individually and then let Lisa know what you think, and I can always amend your ordinance accordingly. But the other option is, you don't necessarily have to decide all of those things before you get to your public hearing on the text amendment, because we can always address that in the text amendment hearing. We just have to talk about it in that text amendment hearing
Oh,
and
so
come
we
to a
could-
resolution.
Okay, so we can talk about whether we're gonna
Yep.
do it or not, as long as it's in the public hearing.
Yep.
And then if we go right into a board meeting to pass, that would be
That's okay.
given that condition.
Yeah, but
whatever it is.
Yeah, we'll have to talk about that. The thing you can't do, restriction on text amendments is county board, let's say we don't discuss an issue at the text amendment hearing, okay, during that process. The board then can't bring it up during the board meeting and go, oh, well, we wanna add this provision that wasn't discussed and hasn't been part of an ordinance yet, or a draft ordinance, so you can't.
No sneaky peeks.
Correct. So you kind of have to vet it all in public and then, so I think you guys are well on the right track and you're fairly well protected with your ordinance now. So none of these things you have to decide right now. So you can take your time, think about whether you want those LaSalle Sinclair factors or not. That's probably the big thing you just have to decide.
Well, we're not gonna be back together unless we have a study session until the 12th. So,
Yeah,
so these factors are number 12, basically.
correct, there is 7.
Okay, 7 factors, okay. Yeah, those are.
What's the application fee
See,
used for?
I don't
lot-
wanna
don't
do
want
it.
money.
I don't know, those are
What's it
really,
used for? Lawyer fees and
Subjective.
so
some very
forth?
subjective.
Sorry.
You're okay.
I'm
There's-
sorry.
No, you're fine. Typically, the application fee is used for the attorney's review of the application, the public hearing itself.
Okay.
There's usually a court reporter that we use for the hearings. There's typically, sometimes on a bigger project, we have a hearing facilitator help keep order, just to make sure the hearing goes smoothly. And then
That's me.
Well,
and then, if the project is approved, there's a number of agreements that get negotiated between the county and the developer. So it all goes to that.
it seemed like a lot of money. So I'm kind of tight with my money, so.
I get you. I'll just tell you from the point an application comes until a special use is, or until the building permit. It covers the fees between the application and before they apply for a building permit. It's not uncommon for a big project to exceed 6 figures on that issue.
6 figures?
Yeah, it can be. Now, not always. I mean, I've had some really large ones where the fees, like very large projects, where the between application and the building permit, we spent $40,000.
And that can
Or
come out of
20,000
the 250 max?
That comes out of that.
Okay,
Yeah.
but I thought you were talking about the actual building
No.
permit fee.
No.
Okay.
Usually your building permit fee, and what I would suggest is that if you're comfortable with not having a large fee, what I would suggest is you have a cap to it, that maybe that building permit fee is somewhere in the range of $100,000.
I agree.
That way you're not dinging somebody, they're gonna have to pay costs, you know, if there's costs after the fact. There are tax dollars too that come from a project, so. Wind farm world, different world. Solar world, I'm a little more comfortable in suggesting a lower building permit fee, but just food for thought.
Is that refundable too?
What we
You
don't
know,
use.
On the building permit side, the idea is that you're trying to cover your costs over the life of the project. And that you're not going around chasing the developer for costs.
But
after
there
the
is
fact.
another step
Yeah,
measure in the other portion that says
yeah,
cost incurred during the life of the project.
yeah. So, you're fairly, right now, you have got a pretty good ordinance. B, these are just kind of, do you want to include those items or not? And so, you know, what I would tell you, LaSalle's and Fairfactors, some counties include them, some don't. It's a much easier public hearing if you don't have them there.
Right. Do you have a
Just
lot
tell
of
you.
issues with those?
On highly controversial ones,
Yeah.
you get into that.
Okay.
You know, if you have a really controversial project come before you, those issues are gonna come into play.
Okay.
Yeah, and that's where we're gonna wind up in court.
Right,
Yeah.
that's what I.
And that's, if they're not in there,
Yeah, it's up to, again, up to you. I got some homework, I'm gonna fuse in sort of a process, a procedural process into the ordinance, just so that everybody has it and understands what it is. And B, my other homework was fees for the life of the project.
and then the $100,000.
Yeah, which I'll put in, I could put that in. the
Anybody
document.
disagree with $100,000 on the permit?
And just like the noxious weed, I think that needs to be in there.
Oh, yeah, but
And
that's one of the conditions.
agriculture.
It's in there,
Yeah,
it's in the ordinance.
It's in the ordinance.
Yeah.
I think everything you've got here,
Yeah,
other than, I don't understand the LaSalle Sinclair thing, but everything else, I think everybody kinda agrees.
Nobody understands the LaSalle Sinclair stuff, so it's,
what you can do is leave it in at this point,
yeah,
and then we can discuss it
Right.
at the hearing
correct.
and tell them no. And then we'll-
Yep,
Yeah.
totally acceptable.
Is that fair?
Yep, you can do that.
And you understand why we're sticking with $100,000 for the fee, permit fee itself?
Yeah.
I mean, you did understand that.
We've been tracking, I've been tracking so far, and
Alright.
I think,
Well,
well,
I'm not asking you to agree to it, I'm just saying,
yeah, and I think key to that question is, we'll look at the whole ordinance kind of in its entirety and provide any feedback that we may have.
Yeah.
that's fine.
For sure.
And of course, we can discuss anything at the hearing then.
Yeah, and just to make sure we're tracking as well, you're thinking that the study session and the first study session in May would be the next time this is discussed, or would that be the public hearing date?
No,
Okay.
no, the public hearing day would be sometime after the 14th,
Okay,
but before the 31st of May,
okay.
right?
Last,
Yeah, we
Pretty quick
just,
after the 14th.
we have to notice it, and if on the 14th, your idea is, hey, county board, we're good with this, let's move forward with the text amendment, then we probably would aim to publish that, and I'm sorry, I didn't catch it, but is it published every Thursday?
Friday.
Friday?
Well, it
And
comes
then-
out on Thursday though. I buy my paper on Thursday.
Yeah.
Yeah.
That's when we get it, but the publication date is Friday, everything will be dated for Friday.
Oh, is it? Okay.
I gotcha, and then, when do you need that? How many days in advance?
The Friday before, the Friday you want to publish.
Okay, I gotcha. So if your meeting was on the 14th and you guys were good with it, we would have the notices ready to go to the newspaper on the 16th. That
So
works?
essentially, 1 week before you want it to appear is when you need to
Yeah,
have
it
it.
would appear the 23rd.
23rd, and then you need at least 15 days from then, so.
Well, that's not gonna work.
well,
That's not gonna get us
But
done.
we just by the end of May.
So you could hold a hearing on June 9th.
right.
Yeah. to get hold of sometime that week
Or
to adopt it.
would that still get us?
You would have enough time then to, if the ordinance is in place and they apply right away, then you have to hold a hearing within 60 days. So, but we can always hold it earlier. You don't, it's not that you have to hold it on day 60. You can always, then we would need 15 days. Let's say they applied on say theoretically applied on the 11th, we could post a notice on the 13th, or give the paper the notice on the 13th.
Well, correct me if I'm wrong, guys. We're agreeing to leave the LaSalle deal in and discuss that at the hearing. We agreed to the 100,000, and the obnoxious is already in there, and he's gonna redo the other stuff. So what else do we need to agree to? There is nothing else to agree to.
Not much. If you guys are good with that direction, I can always amend it and provide a notice for a public hearing to take place. I
Right.
would just need the date for it.
Right.
And then you guys, why don't you do this? Why don't I make those changes? I do need to circulate it to them, because
Right.
we've talked about it in the hearing now.
Yes.
Or meeting. And then I can circulate it back to you. I think Lisa can give me maybe the sign off of, yep, that's what we want. And then I can work with the paper to get a hearing date published. Then I would just need from you what date you want.
Okay.
That's fine. And that way, maybe we can still make it in May.
Yeah.
Okay?
Yeah, you might be able to.
Because I don't think we have anything to agree to on the 14th.
Yeah, I don't think so, as long as your direction to me is clear from
Yes.
this discussion. Is that
I've left Lisa out of this. You
No,
haven't.
I'm good.
All right.
Any
Well, you were
questions?
studying, so I didn't. So as soon as you could get us something into them,
Yep,
I think we're on the track. We haven't resolved the LaSalle deal, but
yeah, you can always wrestle that down at the hearing. And it's, you know, the
we
reality
can
is,
talk about it at the study session too.
yeah. Yep.
All right,
We good?
we're good.
I said I would be a half an hour, but
I'm glad we had this.
you gave
Yeah,
a lawyer
no.
a platform, so sorry.
Dan, do you have any more questions? Russ, do you have anything? Andy? Carl? Lisa?
So next we'll attack battery, individual battery, and after that we'll attack
Yep, and I'll tell you what, I have a battery one now, and I'll just circulate it to you guys. Again, this is just
Does it look pretty
standalone.
much like the one that I already have revised, only you just cleaned it up and
Yeah.
the fact that I didn't think you could hold building permits.
Yeah, and it looks very similar. I just changed the staging of a few things, because some of them, you required, like, for example, an interconnect agreement before.
You didn't get one? Oh, you didn't.
Before they would come back, before they were ready, like, for example, at the special use permit application, you required an interconnect agreement and funds for construction, but you don't normally do that, you normally bump that, that's a whole building permit requirement.
Okay,
Alright,
all right, so
Thank you. I'm sorry.
after we get this done, we'll tackle wind pretty quickly.
Yes,
All right.
please. And if things work out that you can move it along, maybe you can piggyback in and we can get things set up for that, okay?
All right,
yep. And then we'll, we essentially work for your state attorney, so we're appointed as a special assistant.
Yes, I handled that.
Yep, and so we walk through that process with them, and some state's attorneys want to be involved in all that, and that's totally fine. Some state's attorneys kind of take a hands-off approach, but at the end of the day, we report to the direction of your state's
Right,
attorney.
and you gotta make sure he's up to
Yep.
date on where you're at.
Yep, and so,
And he communicates with us very well,
okay,
so we're good.
all right. Well, I will plan on communicating with Lisa on point issues, and then if anybody has questions, feel free to reach out to me as we go along, but I've got some homework to do, and I'll get it turned around.
All right?
thank you.
All right,
Thank you.
thanks, guys. Thanks.
Thank you.
Safe trip back.
Yeah, thank you. It's good to meet you all.
Well, we'll see you again, I'm sure.
Yeah. You might get sick of me by the end of it.
Well, not if we get
Not if
done
we're
what we
working.
need to get done.
Yeah, that's
The right way.
Yeah, thanks, guys.
did you have any further comments?
No, I think mainly just to conclude, appreciate the diligence of the board and appreciate you, all the work you guys are doing. I know this is an important issue for you all and it's an important issue for us too, so looking forward to the continued dialogue and much thanks.
Communication, and you'll be getting what he generates and
Perfect.
get it set up, so hopefully, I mean, nobody knows, we can get something handled by the end of May. That's the intention.
Cool.
Okay? We'll go from there. Do we have anything else that needs to come before the week? Okay, Lisa? I thought you said yes.
Lisa, again.
No,
Well,
no.
before we duck out, sorry, do you want, is it okay if we leave? We hate to leave
Oh.
the meeting while it's going on, but if
Oh,
you got more
no, I'm
business.
sorry, I didn't mean to be rude.
No, you're not being rude. We didn't want to be
You're
rude.
welcome
Just
to
exit the
stay
meeting.
or go, whatever
Okay.
you prefer.
Well, I just thought, since I'd introduced myself, I'd just pass out a card just for anybody who's interested. I'll pass one around for everybody here. And thank you very much for your time and attention. And we will be available. I can get in touch with Mr. Kite as well too to get updates from him. So thank you for your conscientious work on this, because I know it's always a tricky thing. So but you got a good captain to help steer you through here. So I'll tell you that.
Thank you.
Thank you.
Thank you very much. Have a good day.
Take it easy.
Be careful.
Take it easy. Yep.
Yes, Lisa.
You and I had talked about, needing to increase the Paris area fire trustee board
Right.
to 5. And I had somebody contact me about that, and that
We just do
that
it.
comes from us.
Yes,
And
we just-
then you ask them for recommendations?
Recommendations, right.
Okay, so can we get that done at the May?
That's what I planned on
Okay,
putting it on.
that's
But
what I
I'm glad you
thought.
brought it.
Countywide,
No,
The big fire.
the Paris Fire Protection District.
so not like Hume and Brockton?
No, we can do
Specifically
those
them.
individually, but they
Oh, I
haven't
thought
yet.
they all wanted that.
I hadn't heard that.
Okay, just,
I've just heard from Ben and
Okay.
Scott.
okay, all right.
So, but I mean, I don't see them.
Well, I thought maybe other people, because you guys were up there at that.
Right,
Well, see, they haven't even picked their 3.
Right,
That's gonna hopefully be on the next, they finally,
yeah.
their attorney quit them. Said, I've had it. And so they found one over in Coles County to take up as their attorney. And she is preparing their documentation for the appointment of 3 new trustees. Okay?
it doesn't have to be an attorney that gives that to us though,
No,
right?
but they prepare their ordinances and make sure that their taxes levy is done, and most of those guys and gals don't know what they're doing there. So that's just one of the functions,
Okay,
and I didn't want to interfere with what all I wanted them to be was open and,
so,
Transparent.
we could vote on it in May, and then we could name 2 additional people in June.
yeah, if they give us names, yeah. Yes,
Just want to talk with the lawyer, right?
yes, the guy in the suit, sitting right
Kind
there.
of figured it.
2 guys in the suits were lawyers.
Kind of figured it.
You can read his
I
card.
think there's the beginnings of the joke there.
You could hear the meter running if you're a little quiet.
I didn't have a card.
Oh, this guy.
No, this one here.
I've been working,
Well,
I've
I'm
been
not
working
talking
with them.
Anything else?
I did.
Oh, and I just got a message, I have not, Bob Swires, remember he was the one that financed, his group financed the
The van.
van. He's finally gotten back to me, and I think he wants to find out who he needs to get in touch
Yeah.
with.
Wonderful,
So I'll get with you, but,
okay.
so I was sick the last time he was through here, and I didn't get a chance to meet with him. So he's swinging through, I'll let you know when he's coming through, and if
Okay.
you want a meeting,
Yeah.
because I may not always be around, and that way you would have, I could pass that contact along to you.
You did what?
He his, whatever he is, he's Eastern Illinois Agency for,
Something or another.
yeah, and they gave money to the 708 board, or,
Mhm. So HRC got a new van, which they desperately
and they
needed.
paid for the whole thing.
Mhm. And they could use one every time they can get the funding. So-
Bob knew I was down here, I met Bob, we were in JC's 40 years ago. So he called down here and says, I've got money to give away, you got anybody that needs it?
Always.
And it wasn't for, I couldn't get it for the jail, but I could get it for that, so.
Okay.
Anyway, anybody else have anything this morning that,
Nothing really.
okay, all right. Anything, Carl?
Mm.
All right. Motion to adjourn. Russ, Lisa, all those in favor signify by saying aye.
Aye.
Opposed, nay. We'll get whatever information as soon as we can to you.